Leaving a gift in my will means trust. I've worked very hard to get to where I am and in a place in my life where I have choice. And I want that choice to be given to an organization that I know will guaranteed do something positive with it.
We're very fortunate to have received a number of significant bequests. One of the most recent ones was from a grateful patient who had a great interest in exercise, but also had heart disease. And we've been able to use that money in research in sports cardiology and exercise.
In our department we have a clinical trials program, but we also have a branch of research which we do ourselves. Research really underpins everything we do. It informs every aspect of how we care for patients, and it means that progress can be made and we can do things better. So it's very validating that that's important to other people as well.
The gifts and wills that we get allow us to, what I would say, value add to the care and the surrounds that we have here at Caritas or within palliative care generally. We're looking at a scholarship for our nurses to undertake some education, and when I say a scholarship, we're looking at all of our nurses at Caritas undertaking this 3-day training.
We're also grateful to be acknowledged that maybe what we're doing has been impactful on patients' lives and improved their outcomes, and that they're grateful.
It really validates the work that we try to do in looking after people the best way we can and trying to do things better all the time.
What it means to have support from our donors is it makes the community that we support evident in the facility that we provide or in the care that we provide. Seeing that people care for strangers that they'll never meet but who will benefit, and that's a gift that we can't give and that we really appreciate that the community does give like this.
I am so grateful and proud to be able to gift in my will to St. Vincent's.
Thank you so much for joining us this morning, everybody. It's wonderful to have you here. My name is Christy Lawler. I'm the Gifts and Wills Manager here at the St. Vincent's Foundation, and we are absolutely thrilled to have so many wonderful supporters present today. And I believe it's actually a bit of a record for us here at the Foundation for a webinar with well over 200 participants present. So thank you so much for taking time out of your busy day to be with us. I would like to acknowledge the traditional custodians of the land on which we meet today and on which our many sites are located. We pay our respects to elders past and present. So thank you again for joining us today. I really hope that you enjoy the webinar as much as we enjoyed creating it for you. So the main purpose of today is to highlight the importance of having a will. A will reflects your wishes and ensures your legacy is secured as you would like it to be. Having a will is very similar to having insurance, and a well-drafted will is a protection for the future you have visualized for your loved ones and the causes you hold dear. Now, Mark Murnane of Murnane Legal is a long-time supporter of St. Vincent's, and we are so pleased to have him with us this morning. He is going to share his expert knowledge on all things wills and estate planning. Mark works exclusively in estate law and understands firsthand the importance of having a well-drafted will, and this morning he will impart a little bit of that knowledge with us. And just before we continue, a little bit of housekeeping. So the webinar will run for 1 hour and it will include a 10-minute Q&A session after Mark's presentation. And thank you so much to everyone who submitted a question. We were overwhelmed by the response. The webinar will be recorded and shared with you via email in the next few days. And if you enjoyed it, please do share it with your friends and family. There will also be a short survey of 6 multi-choice questions following this webinar. And if you wouldn't mind taking a moment or two to complete this, we would be very grateful. And to keep everything flowing smoothly, we have turned off the Q&A option within Zoom. But if you do have questions for Mark or myself, please send through an email and we'll respond to it after the webinar. Now, before I hand over to Mark, I would like to touch on the incredible benefits of bequest gifts for charities, and more specifically for St. Vincent's. For many of us, the scale of the positive impact we would like to create within our own communities may only be achievable through a future gift in our will, but the scale of that impact can be transformative. This graph highlights the incredible impact of gifts pledged in wills for St. Vincent's. And looking at the data from the past 3 years, on average, the total lifetime donation from our generous bequestors was $1,443. The average gift per donation was just over $50, and yet the average bequest gift was almost $210,000, which is absolutely staggering. These were people just like you and I, supporting the charities and organisations that aligned with their values when they could. But as you can see from this graph, a gift left in a will can be truly transformative. Now, the bulk of these bequests were residuary gifts, meaning the bequestor not only ensured their loved ones were provided for when they passed, but that they were able to support the causes that they cared about also. Now, in my role as the Gifts and Wills Manager at St. V's, I've had the privilege of witnessing firsthand the remarkable impact of bequest gifts. Gifts left in a will have funded our cancer research, supported palliative care, aided capital campaigns for new buildings, driven cardiac research, provided specialised operating equipment, and so much more. We are extraordinarily grateful for our generous bequest donors and humbled by the incredible support they offer to St. Vincent's, which is truly life-changing. Right, I am going to pass across to Mark now, who is going to share some fabulous estate planning insights with us. Mark, across to you when I stop sharing.
Thank you, Christy. Welcome everyone to the webinar. Now, I hope everyone has themselves comfortable with a cup of coffee, something to sit down and pass the time by with me. Now, first of all, this will be recorded, so if you miss anything, you can back it up later and have a look. This webinar also follows on from a webinar I did with St. Vincent's about 18 months ago. So I think Christy and the team are going to be putting up a link for that video, that webinar we held then. Okay, so just one moment, I'll share the screen. Okay, so what we is all unique. So the advice that we will require will be unique as well. So after saying all that boring bit, I'll get that out of the way and we'll move on to our first slide. So what we'll be covering off today is what happens if you die without a will? What is a grant of probate? So people might have heard the word probate. We'll answer that question for you. What happens if a will is lost? So if the original will cannot be found, what needs to happen? What is a family provision claim? Okay, so we'll explain all that later. Don't worry, you won't know what that is at the moment, or you may not. And how do I leave a gift in my will to a charity? Okay, so we'll move on to the next slide. So the aim of today's presentation. The aim is to follow on from our previous presentation of how to make a will. The aim of this webinar is to inform participants of some of the common mistakes that can arise. Today, we'll look at 5 will-making scenarios I've come across during my legal career. So we've changed the names. These are the sort of things that can go wrong if you don't get your will correctly drafted or don't take all the right steps to make your will formal. So we're all on the same page. Well, figure out what is a will. A will is a legal document which sets out who will receive your property and possessions when you die. When you have a valid will, you give yourself the best chance of making sure your assets go where you want them to. So you should always make a will if you have a family or if there are others who are financially dependent on you. So we'll cover off later, I guess, who the financial dependents are when you're making a will, who you should be thinking about. Legal lingo. So just to help everyone understand a few terms that I'll be using in the presentation today, just so you all understand what these terms mean. So a beneficiary is simply someone who benefits from a will or from your estate. Now, your estate is all of the property, assets, liabilities, and debts belonging to a person that at the time they died. An executor, that is the person who will step into the shoes of the person who's died, the person who made the will. So they're appointed through a will to be the executor. Now, intestate. Intestate means you've died without a will. So we'll cover off what happens when someone dies without a will, but the important thing to understand is the term is intestate when you die without a will. Probate. Now, when you hear the word probate, think of the word proven. What probate is an application to the Supreme Court to formally approve the last will and appoint the executors under the will. So it makes it all official. So what the court is essentially doing is proving the last will. They're putting it under some scrutiny and they're making sure that that will meets all the formalities under the legislation, that there's no dodgy dealings going on, there's no fraud. They check over that. And if everything's okay, they'll give you what's called a grant of probate. And last of all, a testator. A testator is simply a will maker. It's just an old fancy Latin word that's still around today in the state law. So first of all, what happens if you die without a will? When someone dies without a will, they die intestate, and the rules of intestacy apply. The rules of intestacy slightly different each state. So what happens in Western Australia will be different to Victoria and, say, Queensland. However, when you die without a will, the state's legislation divides your estate through a formula. So, and that formula is based on your domestic relationships, such as your spouse or what the old term was de facto partner, or your family bloodlines. So we'll have a look at actually in Victoria what happens and how it's divided up. So in Victoria, when a person dies without a will, their estate is distributed according to the intestacy laws outlined in the Administration Probate Act. So the distribution follows a specific hierarchy based on surviving relatives of the deceased. Okay, so the first person in line of the queue, so think of it of a line of people, is the spouse or the domestic partner. Okay, so they're first in the queue. It may be an issue if you have multiple partners, multiple domestic partners, but we won't worry about that too much. So if you don't have a partner, the next step is if there's a spouse or domestic partner and children, okay? So if the estate is worth the exact amounts in the 600,000s, it's indexed, okay? But if there is a spouse and there's they receive all the personal chattels, and then the first part of the estate, the 500,000, that's the number that's indexed. That goes to the spouse. And then anything over 500,000, half of the remainder is divided between the children and the spouse, okay? So it's a little bit complicated. The formula is a bit complicated, but if you have a will, you don't have to worry about this, but we're just outlining what happens if you die without a will. It gets a little bit complicated, that step. Now, if you don't have a spouse, then it's children, and then no spouse, no children, it's parents, siblings, then it gets further out. Now, if you don't have any living relatives, it's the state government. They'll receive your entire estate. Doesn't happen as often as people probably think. A lot of you the state government, that's not correct, okay, as we've seen here. It's mainly who is your domestic partner, then further out, who are your blood relatives. And as it says here, the intestacy laws ensure that the estate is distributed to the closest living relatives of the deceased, following a predetermined order of priority. So what happens after all of that is a spouse or relative are required to apply for a grant of letters of administration to the Supreme Court to be able to administer a deceased estate. Okay, so what we'll do is, the first thing we'll do is look at a case study. Now, as I mentioned before, these kind of scenarios do come up when you're an estate lawyer. And what I've done is I've sort of merged or mangled a few of the scenarios together, and to give you an example of what can happen. So I guess they're extreme cases, but it's an example of why you shouldn't go down this path. And we'll explain what the person or the will maker or the deceased could have done to make the situation a bit better. So we'll go slowly through this just so you understand it. The facts are important. So we have the lady here, Victoria Bitter. She died separated from her husband. His name was Melbourne. Okay. Now this is important. This next little fact. Victoria and Melbourne were separated for 20 years prior to her death. Now, the important thing is Victoria and Melbourne weren't divorced. Okay. Victoria and Melbourne have 2 adult children. Their names are Billy and Betty. Victoria had a nasty and bitter separation from her husband, Melbourne, however, did not divorce him. Victoria and her children were all estranged from Melbourne. So Billy, Betty, and Victoria, they're all on one team. Then we have Melbourne on the other. No one's having any communication with Melbourne. Importantly, Victoria did not repartner after her separation from Melbourne, and neither did Melbourne. Victoria had stated she wanted her estate to be equally divided between her children, Billy and Betty. Unfortunately, Victoria died without a will, so the rules of intestacy apply. So those rules and those distributions that we just looked at before, this applies to Victoria's scenario. Now, Victoria died with an estate worth $400,000. Now, if you remember back, I provided that amount of $500,000. So for estates less than that $500,000 amount, it goes entirely to the surviving spouse. If it was above that $500,000 amount, there would be a distribution to the surviving children as well as Victoria. I don't want to complicate this too much. We'll keep it simple. So after Victoria's death, her children, Billy and Betty, went to see the local lawyer. Billy and Betty told the lawyer Victoria did not have a will and that Victoria had told them that her estate is to be equally divided between them. The lawyer asked Billy and Betty if Victoria was divorced from Melbourne. They said Victoria was not divorced. The lawyer explained that without a will, the rules of intestacy apply. Under the rules of intestacy, because Victoria and Melbourne were not divorced, Melbourne is considered to be her spouse and he will inherit her entire $400,000 estate. So that would have been a bit of a shock to Billy and Betty when they've heard that from the lawyer. But they went off and they contacted Melbourne and they explained to Melbourne the situation, stating that Victoria wanted her estate to go to them and not him, not Melbourne. They hoped Melbourne would assist and disclaim his share of the estate. So what that all means is they were hoping that Melbourne would say, okay, kids, because we were separated, I won't make an application to the court to receive Victoria's entire estate. But Melbourne laughed and he said, that's tough luck for the kids. So then what happened was Melbourne applied to the Supreme Court of Victoria for a grant of letters of administration to administer Victoria's entire estate. And effectively, in the end, Melbourne got the entire estate. So the next thing is looking back. What could Victoria have done better to avoid her entire estate going to Melbourne? So option 1 is divorce Melbourne. If Victoria had divorced Melbourne, Melbourne would not have been considered a spouse under the rules of intestacy. That simple. So divorce cuts off any ability that the ex has of making a claim against the estate. in most circumstances, okay, if there's still child support payments or something like that that needs to be paid, they may have some claim against the estate, but the vast majority of circumstances, they won't have a claim against the estate. Option 2 is make a will. Victoria could have made a will that divided her estate equally between Billy and Betty. The rules of intestacy would not apply because Victoria has a will, of course. So we all know that, we all understand that. And then go and make a will. The best practice, though, is when there's a separation that occurs, is then make a will, then divorce, and then maybe update your will if necessary. Okay? So the lessons that we can take out of that is, without a will, you have no say how your estate is distributed after your death. Your estate may go to relatives, so they may benefit, who you don't want to receive anything from your estate for varying reasons, maybe estrangements, or maybe they don't need anything, they're well off themselves. Now, point 3 is, without a will, you have no say who will administer your estate. So the legislation states who will be effectively in control of administering your estate. They'll be appointed by the court. The nearest of kin or the next of kin will be that person. So if it's not your spouse, it may be a child, it may be a brother or sister, it could even be a parent, okay? You may have a relative administer your estate who you do not want or is unsuitable to manage your estate. So you may have a family member who can't manage their own affairs. You don't want them managing yours after you're gone. That's simple. Without a will, you get to appoint who the executor of your estate is. So if you have a will, just as I just said then, you say how your estate is distributed after your death. You may be able to leave relatives out of your will who you're estranged from, are financially well off, or do not require an inheritance. But that is fraught with danger. You probably need legal advice when you're cutting out dependents from a will. Okay, they may have a claim later on against your estate. A good, smart lawyer will give you some advice, provide you with some options to mitigate the chances of them having a successful claim later on. And you can choose an executor to administer your will when you have a will. Okay, so quite simple and straightforward. I think we can all understand that. Okay, so the next point we're moving on to is, what is a grant of probate? A grant of probate in Victoria is a legal document issued by the Supreme Court of Victoria. It authorises the executor named in a deceased person's will to administer the deceased estate. This involves collecting the deceased's assets, paying any debts and taxes, and distributing the remaining assets to the beneficiaries, as specified in the will. The grant of probate serves as proof that the executor has the legal authority to manage the estate. Okay, so I won't bore you with this for too long. This outlines the application process for a grant of probate. So the main thing I really want to draw people's attention to are these two items here in the application. Please note it's the original will. The original will must be submitted with the application. If the will is lost or destroyed, an application for grant of probate of a copy of a will can be made, but this requires additional evidence and affidavits. And you've probably figured out too, it's probably going to come with some extra costs. So you need that original will. It needs to be found. It needs to be carefully delivered to the court. The other thing that is required is a death certificate. In recent times, the births, deaths and marriages in Victoria now have 2 death certificates. The death certificate that the Supreme Court requires is called the cause of death certificate. Okay. And then further on, there's a few other little items. Just of interest there, you'll see down the bottom here, notice of intention to apply for probate. You may remember the advertisements in the local newspapers letting everyone know that the executors are going to apply for probate. That doesn't happen anymore now. Probably in the last 10 years, I'd say it would be. The Supreme Court has a page where all the advertisements are now advertised. That lets people know that the application is going to be made. If they want to object, they can. They've got 14 days to object, but once the 14 days passes, the executors will be applying for probate. So if you want to see more of that slide, I'd suggest having a look at the recording later on and pausing on that. So what we'll do is we'll look at case study number 2. It's the estate of Mr. Willie Badwill. Okay. So the facts are, Willie was at the post office one day and saw a will kit. The will kit was cheap and Willie loved a bargain. Willie last made a will when he was 21. He thought it was time to make a new will that included his domestic partner, Wendy. He purchased the will kit and took it home to complete. Willie was 40. He and Wendy have 2 young children. His major asset was his $500,000 worth of BHP shares inherited from his mother. He wanted Wendy to have his shares should he die. Willie decided he would text his friend Merv and ask him to come to his home and witness him sign the will. Merv arrived early and Willie felt a bit rushed. Willie thought a few blank spots here and there in the will won't be a problem. Willie thought the main issue is that the will is clear and he intends that the BHP shares go to Wendy. Willie told Wendy he had made a will and placed it in their filing cabinet. 1 year after making his will, Willie died suddenly at home. Willie remembered Willie had made a will. So then Wendy's contacted the BHP share registry to tell them that she has Willie's will and she's been left his shares. The BHP representative said the shares cannot be transferred without a grant of probate. BHP suggested she contact a lawyer to assist her with a grant of probate application. Wendy contacted her local estate lawyer and explained her situation. Wendy said she would like to retain the lawyer and proceed with the probate application. The lawyer requested a copy of the will to peruse. Wendy emailed a copy of the will to the lawyer. Okay, so the lawyer reviewed the copy of the will and he noticed that the will had the following issues. Firstly, there was no date on the will. As Willie had a previous will, extra proof will be required to show the court that the will that Willie had made 1 year ago was his most recent will, and that will revoked his previous will. Now, Merv was the only witness to Willie's will. 2 witnesses are required in Australia when a will maker signs a will. So we've got a problem here. There was only 1 will maker. And Willie had left the section in the will blank for an executor. He didn't name anyone as the executor. Now, as we'll find out, that's not, I guess, fatal to the will or to the probate application. To ensure that probate was granted, the lawyer was required to meet with Merv. So he was as he was the witness to Willie's will. The lawyer asked Merv if he could find the text message from Willie asking him to witness the will. Merv found that text from Willie asking Merv to come over here and witness my new will tonight. I need to change my will. So what the lawyer then did was drafted an affidavit on behalf of Merv, stating Merv affirmed the affidavit, but he drafted it for Merv, stating Merv was the witness to Willie's last will. To the best of Merv's knowledge, the date of the will is the same date as the text message he received from Willie. So also in Merv's affidavit, he affirmed that neither he nor Willie were aware 2 witnesses were required for a will. If Merv was aware 2 witnesses were required at the time of signing the will, he would have found another witness. Merv was of the view that Willie intended for this document he witnessed Willie sign to be Willie's last will. Because the will did not have an executor, Wendy, as the beneficiary with the greatest interest in the estate, was required to apply for a letters of administration with the will annexed instead of a grant of probate. Okay, so it's just a slightly different application, but the will still stands up, okay? So that affidavit that Merv has given or has affirmed was part of the letters of administration application with the will annexed. So that wasn't enough for the court because the will was deemed to be informal. A hearing was held with a judge. She accepted the application and granted letters of administration with will annexed. So that was granted. You probably get the picture though. It's not a cheap exercise to draft extra affidavits and then appear in front of a judge. So straight away, the costs that Willie thinks he might have saved are starting to get away. And as I point out here, the lawyer charged Willie's estate extra fees for Merv's affidavit and the meeting with Merv. Wendy provided BHP with a grant of letters of administration with will annexed, and the shares were transferred to her. Now, that's a pretty simplified version of the scenario, but it was along those lines where two friends sort of got together and decided to make a will, didn't know they needed a second will maker, signed the will, and then, I guess, for want of a better word, the mess had to be mopped up afterwards, okay? What could Willie have done to avoid his estate incurring extra costs to transfer the BHP shares? So this is where I guess if you had some advice from a lawyer, things might have looked a little bit different. What could Willie have done to avoid his estate incurring extra costs to transfer the BHP shares? Now, quite simply, you'd be amazed, but Willie could have followed the instructions on the will kit. It amazes me how often with the will kits, people just don't follow the instructions. I guess that happens in life with a lot of things. People don't follow instructions for whatever reason, but that's what happens. Willie could have met with a lawyer. And the benefit when you meet with a lawyer is not only the drafting of the will, but you'll get some suggestions and some advice. Whether you take on that advice, that's your choice. But you'll get some advice, and that's where the extra value comes from, where you meet a lawyer rather than, I guess, an online will or a will kit or a do-it-yourself will. The lawyer may have suggested a testamentary trust will, so the BHP shares are held in a testamentary trust. And the benefits of those BHP shares being in a testamentary trust are, if Wendy was to repartner, the shares would not form part of a property settlement if that future relationship of Wendy's was to break down. Okay, because it's in a trust, it doesn't form part of a property settlement. And there may also have been tax benefits allowing the trustee to make distributions from the trust to Willie, the trust from Willie's will to Wendy's children. I don't want to bore you too much with testamentary trust wills, but they're a great way of protecting assets, keeping the wealth of the family in the bloodline, and it's also a great way of minimising tax. But we could do probably 2 or 3 webinars on testamentary trust wills. If you've got an estate probably worth more than $500,000, it's something you should be considering, or at the bare minimum, a lawyer should at least be suggesting a testamentary trust will. Whether you want to go down that path is a choice for you. Now, the lawyer may have suggested to Willie making Wendy a joint proprietor or a joint owner of the shares. As a joint, I've just got this covered here with some writing here, but as a joint proprietor, the shares would automatically transfer to Wendy on Willie's death, and Wendy would not require a grant of probate to transfer the shares. Now, quite often with shares and bank accounts, that's a part of a bit of the extra cream on the cake when you see a lawyer. They'll make suggestions so the assets don't have to, I guess, flow through or be distributed through the will. So if you have a spouse, it may be a good idea just to have a look at whether the assets should be held as joint proprietors. When you're joint proprietors, the share automatically goes to the surviving spouse. So it automatically goes. You may have some paperwork, or you likely have some paperwork later on to take the deceased partner's name off. Well, estate planning is more than just a will and signing off on it in 20 minutes and having it done and then moving on to the next thing. Estate planning is a great way of looking at a holistic view of your I guess, of your assets and how you want to move it to your beneficiaries. Okay. So, and this is just a slide that I've seen and I really like. For people like Willie who are cost sensitive with estate planning and wills, please consider this. Now, there'll always be someone who charges less, no matter what in life. But with a lawyer, we see this a lot. There's always someone saying, lawyers are expensive, lawyers are bad, lawyers are evil. Like anyone in any industry, there may be the odd person that doesn't always follow the line, follow the rules. My experience with estate lawyers, the vast majority are good people. We're dealing with death. A good estate planning lawyer should be looking at mitigating the chances of a family dispute later on. That's the first thing that we're all trying to do. And then we're trying to get your estate planning in a fashion so it can move to your beneficiaries in a way that you want, and providing some advice and some options and alternatives. It's up to you whether you actually take that advice on. You can ignore it, but it's a good idea just to have some ideas run past you, how things might be done better. You don't know what you don't know, as the old saying goes. So the next case study we want to look at is losing a will, okay? The estate of Mrs. Lucy lost a will. Now, Lucy is in her 80s. She's widowed with one child, Fred. He lives in a flat in the backyard. Now, Lucy's worth $5 million. She recently made her first will. So this is important, her first will, with a template she found online. So she's printed the template off and just filled in the gaps. She kept the original will in a cupboard at home. She did not make a copy of her will. In her will, Lucy makes her nephew, James, her executor. She tells James he is the sole executor and where the will is located. She does not tell James the contents of the will. Fred cannot hold down a job. Lucy is concerned if he receives a large inheritance, he will soon waste it. Lucy's will leaves $2 million to various charities, and Fred receives the remainder of Lucy's estate, including her home. When Lucy tells Fred he is not getting her entire estate, he is furious. Lucy tells Fred where she has placed her will. Lucy had what was expected to be a short hospital visit soon after making her will. However, she sadly died in hospital. After hearing the news of Lucy's death, her nephew James waited a week and went around to Lucy's house to find her will, as he was the executor. James searched the cupboard but could not find Lucy's will. He then searched Lucy's whole house and could not find the will. James asked Fred if he had seen Lucy's will. Fred said he hadn't. After weeks of searching, James gave up. As the will cannot be found and there was not a copy of the will, the rules of intestacy apply. So, as Fred is Lucy's nearest relative and only child, he will inherit Lucy's entire estate, and the charities will miss out on their share of the $2 million gift from Lucy's will. So then what happens is, as the nearest relative, Fred applies to the court for letters of administration and ultimately receives Lucy's entire estate. Now, I guess we're all suspicious of Fred, thinking that, he might have been a magician and made the will disappear. You can never prove that, but this is the number one issue of when you store your will at home, of it not being found. Now, if you think Fred has made the will disappear, I just want people to be aware it's a dangerous thing to be thinking about, because under Section 8 of the Crimes Act in Victoria, it's an offence to dishonestly and with a view to gaining for themselves destroy, deface or conceal a will or other testamentary document. This is an indictable offence and is punishable by up to 10 years. So even though some people may be tempted, it's a criminal offence. Don't do it. So what could Lucy have done to avoid her will going missing? So Lucy could have made her will with a lawyer. That's the word will. Most law firms store wills free of charge and provide the will to the executor after the will maker's death. Now, what the arrangement is and what the fees are to store the will should be outlined in a cost agreement when you sign that with a lawyer. If you're making a a will with someone that's a non-lawyer, that's risky in itself. But some of those do have monthly charges for, storing the will, keeping it in safe custody. I would just point out that the vast majority of law firms don't charge to store a will. It's a good idea, as we've seen with Lucy, to have your will stored. Now, the other option people have is, if you don't trust lawyers or don't like lawyers, fair enough, you can deposit your will with the Supreme Court of Victoria. It comes with a fee. I think it's between 35 and 40 bucks now. So that can be done as well. That's a good idea if you'd like to go down that path. Okay, so moving on now, what is a family provision claim? A family provision claim, also known as a testator's family maintenance claim in Victoria, is a legal action that can be taken by certain individuals who believe they have not been adequately provided for in a deceased person's will. So eligible people such as de facto partners, children, stepchildren can make a claim against the estate. Now, that's not exhaustive, that list either, but that's just an example. Can make a claim against the estate if they can demonstrate that the deceased had a moral duty to provide for them and the will does not make adequate provision for their proper maintenance and support. To succeed in a family provision claim, the claimant must show that they have been left without adequate provision and the deceased had a moral obligation to provide for them. The court will consider various factors, including the nature and duration of the relationship with the deceased, contributions and financial circumstances. Okay, so we'll have a look at this case. Now, this is another probably extreme example, but as an estate lawyer, you always see blends of these kinds of scenarios. So Larry is single. He's newly divorced with twin daughters, Lara and Lulu, who have just turned 18 and have no savings or assets. They live in Larry's rented home. Larry is very confident in his own abilities. Larry has never met anyone smarter than him. Larry is best friends with his younger brother, Gary. Gary laughs at Larry's lame jokes. Gary never complains when Larry makes him the butt of all of his jokes. Gary has made a fortune out of Bitcoin, and Larry is proud to finally have someone in the family make it rich. It annoys Larry that his daughters Lara and Lulu do not have a close relationship with him. However, Lara and Lulu find Larry boorish and selfish. Larry is confident if he Googles a will template online, a smart bloke like him can figure out the rest. Plus, Larry thinks lawyers overcharge and do not add any value. Larry made a will making his brother Gary the executor and sole beneficiary of his estate. Larry left nothing in his will to Lara and Lulu, Lara said they can learn to survive in life like I had to. Larry said Larry had never heard of a family provision claim prior to making his will. Soon after making a will, Larry died with a $500,000 estate. His daughters soon received an eviction notice to leave their rental property they had lived with Larry. For the time being, they moved in with their neighbouring family who took pity on them. In accordance with Larry's will, Gary inherited Larry's entire estate. Lara and Lulu asked Gary if he could give them some money from Larry's estate. Gary said, "Your father left everything to me for a perfectly good reason. It is his will and you should respect his wishes." To survive, Lara and Lulu had no option but to make a family provision claim for a provision from Larry's estate. Lara and Lulu hired an experienced estate lawyer. After receiving letters from Lara and Lulu's lawyer, Gary retained his own lawyer. The matter went to mediation. It became obvious during the mediation that Gary was a very wealthy man and Lara and Lulu had nothing. Gary's lawyers advised him if this matter is not settled at mediation and goes to court, he will likely lose the case and have costs awarded against him. So that's legal costs and probably Lara and Lulu's costs as well. Gary agreed to settle if his legal fees were paid by the estate, then Lara and Lulu can have the remainder of the estate. So Gary said, "Pay my legal fees and it's all yours." At the time of settlement between Gary, Lara and Lulu, the estate had incurred about 12% of the estate's value in legal fees and cost around $60,000. The point is, wrong. What could Larry have done to avoid a legal battle between Gary, Lara, and Lulu? So what Larry could have done is seen an experienced lawyer to draft his will. A good lawyer would have explained to Larry what a family provision is, then advised that if Larry leaves his entire estate to Gary, and if Lara and Lulu were to challenge his will for greater provision, they would likely win. Okay, so that's one of the things a lawyer should do, is figure out the family dynamics, ask if there are any dependents, and then have a look at if anyone has a claim against the estate. And if they do, just provide some advice to the client. And if the client wants to disregard that advice, that's up to them. Okay, that's how it generally works with estate planning. Okay, so this is the final scenario. This is Charlotte Charity. So Charlotte Charity is 45. She's single, never been married, and has no children or dependents. Charlotte is a professional working in the city. She is an only child. Life has been tough since her parents both died. She was disappointed that her only auntie Mary did not contact her after the death of her parents. In Charlotte's spare time, she loves catching up with her friends, travelling and volunteering at her favourite charity. Volunteering at the charity keeps her grounded and gives her a chance to give back to the community. Charlotte regularly donates to that charity. When Charlotte dies, she wants her assets to be distributed between her best friends and the charity. Now, it's important also to note she's never made a will. Now, while Charlotte was travelling, she's had a tragic accident. She never got around to making a will to leave her estate to her friends and her favourite charity. Because she never had made a will, the rules of intestacy apply to distributing Charlotte's estate. So what's happened is Charlotte's auntie, the auntie that she was a bit disappointed in, is her nearest next of kin under the rules of intestacy, and Mary will inherit the entire estate of Charlotte, worth about $2 million. Charlotte would have been disappointed to learn her auntie receives her entire estate, and her friends and favourite charity receive nothing from her estate. So, what could Charlotte have done to ensure her friends and favourite charity receive something from her estate? Now, if someone dies without a will, of course, the rules of intestacy apply, and the rules of intestacy do not include friends and charities. They completely miss out. They're not blood relatives. If Charlotte wanted to leave something to her friends and favourite charity after she died, she needed a will that clearly distributes estate assets to them. The only way a charity can receive a gift in a will is through a will maker specifically leaving something to them in their will. A common rookie error when leaving a gift in a will to a charity is not clearly identifying the charity. A good example where people get confused is, say they say, I leave everything to St. Vincent's. Now, the question is that St. Vincent's Foundation or the St. Vincent's Hospital or St. Vincent de Paul? You need to be clear. You need ABNs, company numbers, corporate numbers, things like that, addresses to clearly identify the charity. Okay, so after all of that, you're probably getting sick of hearing my voice, but here are some closing comments. For a lot of people thinking about making a will, the hardest part is getting started. Book an appointment with an estate lawyer and get the process started. Stop procrastinating. So many people put it off. It's a New Year's resolution, all that kind of stuff, but the whole year will go by and you won't get it done. If you want to make a will, the best time to do it is now. If a domestic relationship breaks down, update your will. Okay, think of Victoria Bitter. If it's over, the marriage is finished or the relationship's finished, make a new will straight away. Cheap wills are not the best wills. Quite often they leave a bigger mess, okay? Think of that artwork I put up there. You get what you pay for. And Willy Bad Will is a good example. Engage a lawyer to draft your will. You don't know what you don't know. A lawyer practicing in the estate area of law will add value to you in the advice they provide. Think of Larry left a mess, okay? If Larry just had have known about family provision claims, he probably would have made a different will. Don't be afraid to ask for a fee estimate and quotes. Ask the person providing advice, what is their experience in the area of estate law? Are they a lawyer? Ask them, do they have professional indemnity insurance? Okay, so if they make a mistake, can you sue them? Will they be covered by professional insurance? Do they have a current legal practicing certificate? After making a will, you should not store your will yourself. A lawyer can store your will for you, most likely for free. Think of Lucy lost a will. Don't assume making a will is easy. It takes lawyers years to become competent at drafting wills. Don't think you can get your first will 100% correct the first time you do it. Leave it to the professionals. It's taken decades to accumulate your assets. Give your estate planning plenty of thought. So my view on making wills, I'm an estate planning lawyer. I do it for a living, so I might be biased. But my view is it's something you should not try at home, making your own will. Leave it to the professionals. And if you'd like to leave a gift in your will to friends or a charity, you need a will. If you die without a will, they miss out. Charlotte Charity is the good example of that. Now, if you're looking for some more information and you're not sick of my voice after all this time, I do have some videos online. If you look up YouTube, Facebook, Instagram, I'm on all those kinds of things. So yeah, I guess back to you, Christy.
Fabulous, Mark. Thank you so much. That was brilliant, and so insightful as well. I really appreciated that the scenarios you shared with us today were based on true stories and potentially situations that any of us could find ourselves in. So yeah, really insightful, really enjoyable. Thank you very, very much. Now we do have some time for the questions that were submitted by our participants when you registered for this webinar. As I mentioned earlier, we did receive a wonderful response in regards to the questions, and so while we won't be able to address all of them today, we'll certainly do our best to answer them in the coming weeks. So Mark, the first question that we have is I have a lot of money in superannuation, which I know can't be left to a charity. How can I leave money to a charity in this situation?
Good question. Now, superannuation does not form part of an estate, okay? Superannuation is a trust, and the trust superannuation control of that trust. Now, when you die, you should have completed what's called a binding death benefit nomination. Who you can leave your superannuation is a very defined class of people, mainly dependents. Okay, well, not mainly, it is your dependents. So spouse, children, maybe someone you're providing for. A charity is not one of those class of people. So you can't nominate a charity in your binding death benefit nomination. So what you need to do is, if you're wanting to leave your superannuation to the charity, is nominate your LPR. And LPR stands for Legal Personal Representative. Your legal personal representative, if you die, will be your executor in your will. Your will then distribute the superannuation. So if it is a charity that you want to leave your superannuation to, it will be the will that will distribute that. You can't directly do it. Whether I agree with the policy or not is another thing, but you can't leave your superannuation directly to a charity through a binding death benefit nomination. I hope that helps.
So, no, that was wonderful. Thank you. Next question we have is, when is a will no longer valid? For example, is there an expiry date or time on a current will?
No use by date on a will. The expiry date, though, really is either when it's destroyed or revoked. So someone shows a clear intention they don't want that will to be in place anymore. So they might tear it up or throw it away. But the most common way a will expires is when someone makes a new will. And when you see a will in most good in all lawyer drafted wills, you'll see the first clause is the will maker revokes all previous wills or testamentary acts. That's the common clause, and that makes your previous will expire.
Fantastic. Thank you. Now, here in Australia, are there differences between states in terms of will requirements?
Okay, so in Australia, the rules for estate law are state-based. Okay, so the rules in each state differ, and they differ a lot in New South Wales to the rest of Australia. So um, ask your lawyer if you've got assets scattered around Australia. Are they aware of the different rules around Australia? In New South Wales, if you gift your assets, I think it's 2 years prior to your death, the court can claw them back if there's a family provision claim. In other states, the courts can't do that. So be very careful making rules in other states, or if you move regularly, probably update your will.
That's very good advice there. And speaking of advice, what is your advice about dividing an estate unevenly between two children? And are there ways to protect inheritance from children's spouses in the event of their divorce?
Okay, so if people think back to the scenarios that we discussed today, okay, the first one with the guy with the two daughters that he cut out, that he cut completely out of his will, Larry left a mess, I think his name was. Family provision claims are a concern. So if you're leaving your estates unevenly to your children, it's a good idea to get some advice from a lawyer. What was the second part to that question? Sorry.
Are there ways to protect inheritance
Yeah,
from children's spouses in
good.
the event of a
Thanks,
divorce?
Christy. Yeah, the second part to that is if you remember back to the guy, Willie Badwill, who had the BHP shares, I suggest that he should have left that on, he could have left that in a testamentary trust to his wife. The same thing goes with children. Now, if you've got a son-in-law or a daughter-in-law you don't really like, don't trust, a good idea is a testamentary trust will. So the assets are held on trust. Your child could be in control of that trust. It depends on how the trust is drafted. Now, with a testamentary trust will, you only get one go at having a trust in your will. If you die without it, the executors can't hold the assets in trust later on. So if you die without that and your child goes through a divorce or a relationship breakdown after you die, the inheritance is on the table, and there's a fair chance that your daughter or son-in-law is going to get part of that inheritance. If it's held on trust and the trust has been administered properly and drafted correctly in your will, it should be way beyond them getting their hands on it, they being your son and daughter-in-law. Hope that helps.
Fantastic. Now we've still got time for another couple of questions, which is wonderful. How defensible is our exclusion clauses for children of the will maker due to a situation of a lack of respect, love, or affection?
Okay, so that would be generally called, I guess, estrangement is a correct legal term, and depends on how you look at it. But the bad news for a will maker is just because someone's estranged from you doesn't mean they don't have a claim against your estate. So a claim being a family provision claim. Tread very carefully of what you put in your will. There, with a lot of barristers, there's differing views on this, on what you should put in your will. So you could be putting a loaded gun in your will. If you say, what was the term they used? If they're lack of love and affection, just remember that argument. There could be a counter argument to that where someone's making a claim against your estate and they say, oh, that's not true. I didn't speak to my mum and dad because they didn't make me welcome at home. They told me to go away. You know, I was dating a Collingwood supporter. I got a tattoo they didn't like, something like that. So they ostracized me. Estrangement is not enough to disclaim someone from your will. They can still make a claim against your estate. Everything turns on fact, okay? Get legal advice before you're putting anything like that in a will. Don't risk it.
That's it. Don't leave it to chance. That is I think, very, very good advice. No, wonderful. Now, there has been a rise in online will platforms, as most of us are probably aware of. What are your thoughts around wills made on online platforms, Mark, and who are they really useful for?
Well, I'm an estate planning lawyer, so I put that out on the table. They create issues, okay? And the issues they sometimes create is the lack of advice, as I've pointed out. They go missing. In some circumstances, they may be okay, but I'm not really sure of what the circumstances really would be. You know, best is to avoid them, okay? It's probably the best way. But if that's a path you want to go down, tread very carefully. Ask all those questions I suggested. If you're speaking to someone on the phone, ask them, are they a practicing lawyer? You know, if they're not, why are you giving legal advice? Can you give legal advice? All those kinds of things. Be careful. That's all I'll say. Tread with caution. I'm not going to bag them. It's easy for me to sit here and bag them. Some people may want to use them even after all the bagging I've probably given them. But tread very carefully, because if you're leaving a mess behind with a DIY will, it could be an expensive exercise to unscramble that omelette for your family and your executors. Because if you come and see an estate planning lawyer, you're paying for one lawyer. If things go bad, you could be paying for 2 and 3 lawyers per hour, and they'll be charging, $500 and $600 an hour. Most estate planning lawyers are fixed fee, or they can give you a pretty tight fee proposal. You know what the amount is. If things go sour with a online will, it could cost you anything.
Brilliant. No, thank you for that. That's very sound advice. Now, we'll wrap it up there because we're just coming up to the 1 hour mark. So I really hope everybody enjoyed this webinar today. As I say, we really enjoyed preparing it and delivering it to you. Thank you, Mark, again so much for your wonderful expertise and sharing that with us. And thank you for your incredible support of St. Vincent's. We are so grateful. So thank you. And thank you to everybody who joined us today. It was wonderful to have you here. As I said, it was over 200 participants, which is phenomenal to engage with that many people in one go. As I mentioned earlier, we will be sending a recording of the webinar out, and it will also be available on the Foundation's website in the coming days as well. So we will start working on that immediately after this. And please do take a moment to complete the survey, as it will provide us some essential feedback from the webinar today, and how we can improve it and what elements you really enjoyed. So thank you so much. Have a wonderful rest of the day, and see you later. Bye.